Thank you everyone for joining us. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different immigration law-related topics. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar today. We will also be sending you a visa guide, a ebook PDF of a comprehensive guide, to all of the visa categories that we will be discussing today that you can use as a resource. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button for our YouTube channel, as we do regularly upload a variety of immigration law related videos that can be a good resource for you. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. So today we are very lucky to have Kelly Weiner, who is partner of the firm with a wealth of experience handling all of these various options available to extraordinary ability individuals and the requirements and considerations for all of these visa categories. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jay. Perfect. So we're going to get started talking about just some of the basic temporary and permanent options that are available to individuals of extraordinary ability. So one temporary option is the O-1A visa. So this is a non-immigrant visa for individuals with extraordinary abilities in the sciences, education, business, or athletics. And there's quite a high standard. It's somebody who has risen to the very top of the field in their profession. Then we contrast that with the O-1B visa. So this is another non-immigrant, meaning temporary visa, but this is focused on people with extraordinary ability in the arts or extraordinary ability in the motion picture or television industry. And so there's different standards for these. So for arts, the standard is distinction. So that means a high level of achievement, evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So we can see that the standard for arts is a little bit easier to meet than the standard for, sciences, education, business, or athletics. So sometimes if you're in a situation where the field is not entirely clear, perhaps it could be considered in the arts. For example, people like tattoo artists, or perhaps, some people who are master brewers. Like sometimes there's fields that are a bit malleable, where there could be an argument for either way. And when you do have that, you may want to consider the O-1B over the O-1A, just because the standard of distinction can be a bit easier to meet. It is important that if you're going for a motion picture or TV industry O-1B visa, the standard is different for that. You have to show you've reached a level of acclaim substantially above that of your peers. So then there's the permanent option. So this is the EB-1A green card. And whereas with the O-1A and the O-1B, you can see there's a distinction where arts is separated out. For the EB-1A, this is all combined. So this visa, or this immigrant visa category, so this green card category, is for people with extraordinary ability in the sciences, arts, education, business, or athletics. So arts is included. And the standard is the very high standard, similar wording to the O-1A. So people who are of the small percentage of people who've risen to the very top of their field of endeavor, who've achieved sustained national or international acclaim, and had their achievements recognized in the field. So if you sometimes, if you have an O-1B visa and maybe you got a really difficult RFE on that O-1B visa and you kind of barely met that standard, jumping right to the EB-1A is going to be quite difficult. In that case, you may want to spend some more time building up your profile, before you go to the EB-1A, because even though, as we'll discuss more later, the regulatory language for the qualifications for the EB-1A and the O-1 are quite similar, the standard to reach that that standard for the EB-1A is harder. So just because, even if you've gotten an O-1A, just because you've gotten an O-1A, it does not mean the EB-1A is a guaranteed thing. You still need to show that you're going to meet this criteria, and we'll talk a bit more later about how to do that. For all three of these categories, you do need to be working in your area of extraordinary ability. So the fact that you are, like, let's say you're an individual of extraordinary ability, and now you want to come and you don't want to work anymore, you want to retire, that's not going to work under these visa categories. For the O-1A and the O-1B, we'll talk about timelines later, but you need to show you have extraordinary ability work for the full length of time you're staying. And then for the EB-1A, you're also going to submit a statement explaining your future plans in the United States and how you plan to continue working in that area of extraordinary ability. One other thing listed on this slide is the National Interest Waiver Green Card. This is kind of a quasi extraordinary ability category. It's kind of, it's different than that. However, we mention it here because individuals who may qualify for do have extraordinary ability may benefit from the national interest waiver, and Jiyae is going to go over that in detail later in the presentation. All right, let's dig a little bit more into the actual requirements for the O-1A visa. So to qualify for this visa, you have to demonstrate that either you have received a major internationally recognized award, such as a Nobel Prize, a Pulitzer Prize, or much more commonly, you're going to show that you meet at least 3 of the following criteria listed here. Obviously better to show more. So if you do qualify for more, you want to show that, but at least 3 is the minimum, and you do have to have a U.S. employer. Let's talk a little bit about some of these, receipt of nationally or internationally recognized prizes or awards. So it's really key. You really want to read the criteria closely, because let's say that you won an award, in your college, for great performance or something like that. That is not going to be good evidence for this type of visa. Most of the time, awards that you win in your undergraduate degree are not going to be, very, considered as useful for this type of application. Let's say, though, while you were a student, you won an award that other professionals in the field had also applied for who were not students. It was not linked to the university and was an internationally, or nationally recognized award. Then that could be used. The fact that you won it while a student would not be a negative, but you do want to be thinking about, exactly what you're including. It may not be the best choice to include everything from your portfolio, if some of that may lessen the, like whether or not they think that you are an individual of extraordinary ability. So for example, one criteria is membership in associations in your field, which require outstanding achievements. So let's say that you are a member of an association that does require you to show that you've met certain success metrics in your field. That is going to be useful, versus if, let's say you are, you're a lawyer and you are a member of your local bar association, and all that's required is that you have a license, you're a licensed lawyer, any licensed lawyer can join, you pay a fee. That type of thing is not going to be helpful, in terms of the O-1A, criteria. They do want to see, oh, you're a member of an association that only allows people who have met a certain standard of success to join. And so you want to be thinking about that kind of throughout the rest of, any of the criteria that you meet. So publish material in professional or major trade publications or major media about you or your work. So again, major trade publications, major media, you want to be thinking about, what are the profile of the places that are writing about you. If it's something like, the New York Times or the Wall Street Journal, those are very helpful, versus if it's, your local newspaper, did a profile on you, that may have less value. So these are the things you want to be thinking about when you're preparing your evidence for the O-1A visa. All right, so let's switch to the O-1B. So the structure of the qualifications are similar. So it's either one, major award, an Emmy, a Grammy. So this is obviously focused more on the arts, or evidence that you meet at least 3 of the following criteria. And you can see the wording of the criteria is much more focused on, you know, what would make sense for people in the arts or the motion picture or television industry. So, you know, sometimes you do have to get creative, especially if you're in one of those industries like we were talking about, you know, like tattoo artists or something like that, where perhaps they're really evolving and there's kind of less, you know, kind of evidence that they would normally see if you were applying as just an actor or a singer or something like that. So there is a category for other comparable evidence for the arts, not for people in the motion picture industry. But it can be hard to use this category because they do want to see that you know, that you really cannot fit into these others. So it may be that you show you meet at least 3 of these criteria, and then you include other comparable evidence that doesn't quite fit because you're trying to show holistically that your profile is that of somebody who has reached the very top of their, you know, reached the top of their field or achieved distinction in their field. All right, so let's talk about some differences between the O-1A and the O-1B. So again, these are the temporary visas that are available to people who want to come and work in the US, maybe just for a few years, or maybe there's a, you know, a production you want to join or, you know, a business you want to start. So for the O-1A, this is the areas of sciences, education, business, or athletics. For the O-1B, as we've discussed, it's the arts and motion picture TV industry. The standards are different, as we've talked about. So the O-1A standard is going to be higher, that standard of an individual who's risen to the top of their field, versus the art standard of distinction or the motion picture TV industry standard of, you know, a claim substantially above your peers. When it comes to how long they can be issued, they're treated the same. So you can initially get your visa for an approval from USCIS for 3 years. And then if you're finishing out, like you're extending, let's say you have like a, you know, an itinerary and you're just extending, you know, the run of the same activity, then your extensions can be granted for 1 year. However, if you can make an argument that this is a new set of projects, or let's say you're changing employers or something like that, then you can get new approvals for 3 years. So it does depend on the facts, but always good to discuss with your attorney to see if you can get another 3-year approval as opposed to having to kind of continually do, you know, an extension each year. And in terms of whether your family can come to the US, yes, your spouse and any unmarried children under 21 can come with you to the United States. Children and your spouse are allowed to study in the United States, but they are not, spouses and children are not permitted to work. All right, so now we're going to move and discuss the EB-1A green card. So this is the extraordinary ability, you know, permanent way to move to the United States. So if you're somebody who says, you know, I want to make my life and my career in the US, you know, you would probably want to go the green card route. As discussed previously, maybe if you're a little bit on the edge, maybe you got your O-1, but it was quite a difficult approval, or something like that. It may be that you want to be in the US on the O-1, continue to build your profile because now you know what the criteria are, continue to publish, you know, make an impact in your field, and then apply for the EB-1A. So the requirements are very similar to the O-1A and the O-1B. There's a slight tweaking of the language because it encompasses both the arts and, you know, business, sciences, education, athletics. Excuse me. But the structure is the same. So it's either one major internationally recognized award or, you know, 3 out of the 10 criteria. Very important to consider here something called the Kazarian analysis. So this is an analysis that came into play after a court case that was decided that really laid out the structure of how government officers are going to adjudicate these extraordinary ability petitions. So in that first step, they're going to look at the evidence to see, have you met that plain language of the criteria? So, you know, have you included proof of, you know, memberships and associations that require outstanding achievements of their members? Have you included proof of your employment in critical or essential roles, you know, at, organizations with distinguished reputations? So they're going to look at that to see, is that evidence there? And then in the second step, they're going to look at it and consider the quality of the evidence in totality. So they're going to make a final determination on the merits that's really going to be based on how do they view, when they look at all of the evidence, does this really show all together, you know, working in totality, that you are somebody who's risen to the very top of your field. And so that goes back to what we were talking about earlier. That's why you don't want to include, you know, student awards or anything that makes you, that would kind of bring down that final merits determination. You really want to focus on the quality of your evidence as opposed to including quantity, if that quantity is going to kind of drag down what your entire profile looks like when they do this final merits determination. All right, so now we're going to switch over and talk about the national interest waiver, which can be a really great option. And Jiyae is going to walk us through that.
All right, thank you, Kelly. Yeah, so let's talk a little bit about the NIW. It is another green card option for people who are looking for permanent residency options in the United States. So let's dig into, some of the differences in how to qualify for an EB-2 NIW green card. So the first requirement is that the applicant must meet the threshold for the EB-2. And this is really the minimum threshold before you can even go and try to prove that you meet the national interest waiver 3-prong criteria, which is laid down below. But you do need to first meet the threshold. So how do you meet the EB-2 threshold? So that person must either show that they have a master's or higher, basically an advanced degree, or its equivalent. So the definition of an equivalent of a master's degree is if you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience after you have obtained your bachelor's, that can also be considered the equivalent of an advanced degree. And so what does that really mean? What does progressive work experience mean, right? So progressive work experience means that your work duties and your, responsibilities and title and salary and things like that, they did not stay the same over the 5 years that you're counting. So you must need to show that, well, first of all, that the experience was full-time, but also you need to show that your duties changed over time. So in order to meet the threshold through showing that you have an equivalent of an advanced degree, you do need to get a detailed employment confirmation letter from your previous employer, basically, confirming the actual period of work and actually that you worked full time there, but also that the duties and responsibilities given to you increased in seniority over time. So a combination of, your bachelor's degree and this experience can also qualify you as someone of an advanced degree professional. Now, let's say you don't have a master, you don't have a PhD, you don't have a bachelor's. Is there an alternative to meet the EB-2 threshold? And yes, there is. There is another way, and that is by showing that you have exceptional ability in the sciences, arts, or business. So how do you prove that you have exceptional ability? So you do need to show that you have at least 3 out of the 7 evidentiary criteria enumerated here. And in addition to showing that you have at least 3 out of the 7, you need to show that, looking at the evidence in totality, that the evidence tends to show that you are someone who is operating at a level that is significantly above what is ordinarily encountered in your field. So let me tell you a little bit about what these criteria look like. So for example, if you have a degree, if it's not a bachelor's, if it's not a master's, but it's kind of an associate's degree or other diploma, you can use that. If you have a license to practice in your field, you can also use that. If you have 10 years of full-time experience in your field, you can also use that as one of the evidences. Importantly, if you have received recognition for your achievements, original contributions to your field by, leading industry organizations in your field, or, professional organizations or government organizations, or, leading peers in your industry, you can collect evidences of such recognition for your original contributions and use that to meet this criteria. And those kinds of evidences will also help demonstrate that you are someone who is operating at a level that is significantly above what is ordinarily encountered. So if you're able to persuade USCIS that you do have exceptional ability in the sciences, arts, or business, you can qualify for the EB-2 threshold, even if you do not have a bachelor's degree, even if you do not have a master's degree. Now, let's say you have met the EB-2 threshold. The next step is to demonstrate that you qualify for a national interest waiver. And the reason why you also need to go through this step is because normally, the other type of EB-2 petitions that we see are petitions that are sponsored by a US company. So if you have a job offer, if you have a US company that is willing to sponsor you, then you don't need to go through the NIW, right? So you can just have, go through employer sponsorship. But in order for the company to be able to do that, they need to go through what is called a labor certification process, where they will test the US labor market and see if there is any other minimally qualified US worker who can take your spot. And only after they have proved that there is nobody, then they can hire you to take that spot. What the NIW does is they exempt they exempt this case from going through that process. They exempt the individual from having needing to have a job offer. They exempt the individual from needing to have a US sponsor because their work is in the national interest. And that is why you need to show that you meet all three prongs of the national interest waiver in order to, what is called self-petition for a green card, right? So the EB-1A is another, popular green card category for people with extraordinary ability who can self-petition for a green card. So if you qualify for an EB-1A extraordinary ability green card, as Kelly mentioned, you do not need a US job offer. Similarly, if you can qualify that you merit a national interest waiver through the EB-2 NIW category, you don't need a US job offer. You don't need a US sponsor. You can self-petition for your own green card. So this is why, this can be a particularly attractive category for many people. Now then, how do you prove that you merit a national interest waiver? So you need to go through the three-prong matter of Denizar test, and the first prong is to prove that your proposed endeavor, your proposed work in the United States has both substantial merit and national importance. The second criteria you need to prove is that you yourself are well positioned to advance this proposed endeavor. And the third criteria that you need to prove is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification for your particular case, either because your work has such broad impact to the field such that the large scale benefits outweigh the ordinary benefits of, saving one job spot for one US worker, or because you have, unique skills and know-how that is advancing the field as a whole that cannot readily be replaced by someone who has minimum credentials in your field. Or in other cases, if you're an entrepreneur and if your business endeavor will create a high number of US jobs, especially in a economically depressed area, then those kinds of job creation benefits will definitely greatly outweigh, the ordinary benefits of a labor certification, which is intended to protect the labor supply, protect the job market of the United States. So let's dig a little bit more into what these mean. So the first prong, the proposed endeavor has both substantial merit and national importance. So substantial merit and national importance can be proven in a wide variety of fields. So you may be active in business, you may be active in healthcare, education, science, and technology, and endeavors that tend to further human knowledge in those key areas, such as medical advances or improvements in civil engineering processes, for example. If your work tends to bring innovations in these areas, that can be an endeavor that is well suited for a national interest waiver. Now, endeavors that have a potential to give a strong positive economic impact to the United States is also favorable. So really the question you want to ask is, what is the future impact of my work in the United States? Will it just positively impact my immediate employer? Will it just benefit my immediate clients? Or will it cause, advancements in the field more broadly? Will it cause the United States to become more competitive in the global industry in key areas such as cybersecurity, clean energy, healthcare, AI, machine learning, things like that? And how is that important to the United States? Can you make a persuasive argument that your work specifically will create those broad positive impacts to the economy and society? So government reports that, reiterate the importance of certain key areas to the government can be a positive addition to your case to really build that narrative of how your work is of national importance. The second prong, you yourself are well positioned to advance the endeavor. The focus is really on the individual himself or herself. So you would highlight your relevant education, your relevant experience. Really, you're trying to build a portfolio of a record of success in previous related projects to the work that you're proposing to do in the United States. And that is why there can be a good synergy with the EB-2 NIW and the EB-1A green card, is that if you already have a record of success, a record of achievements through which you're well recognized in your field as a leader, you can use these examples to, demonstrate why you're well positioned to continue making such, ripple effects, broad impacts to really pushing the envelope of your field as a whole. Now, the third requirement, it will be beneficial to waive the requirements of a labor certification in your particular case, as I alluded to before. You can argue this in multiple ways. You can emphasize the broad systemic benefits that your work can bring if you are someone of an innovator. You can also talk about the irreplaceable know-how and experience that you bring, really, emphasizing the prong to well-positioned evidence. You can also, if you're an entrepreneur, point to the positive U.S. job creation impact that your business endeavor will have, which counterbalances the ordinary benefits of having the labor certification system to protect the job supply of the United States. Okay, so now we'll shift gears a little bit and talk about expert opinion letters, which is an element that plays an important role in all of the extraordinary ability categories that we have talked about, including the O-1 visas, including the EB-1A, and also EB-2 NIW petitions. So the expert opinion letters play a kind of a different role depending on what category you're trying to prove, and also what is the strategy you're adopting for the case. So if you think that your evidence is lacking in a particular area, you may want to supplement expert letters to really strengthen those weak areas. So expert letters can play a very important strategic role in all of these cases. For example, for EB-1A and O-1A petitions, you would want the experts to confirm that you have extraordinary ability in your field. And not only that, that you really want to develop a narrative of what you do differently from others in your field and why this was important to your field. So that you really want to develop a narrative that will show, not tell, the USCIS officer of why you are a leader in your field. And through that, you really want to prove that you do have sustained national and international acclaim in your field. Now, what about EB-2 NIW petitions? What role does expert letters play in such petitions? So certain types of NIW letters can support the national importance of your proposed endeavor, such as a letter from a government agency or a letter from another leader in your field that can really provide more context to what you're planning to do in the United States. What is the limitation in the industry that you're addressing, and what kinds of broad impact to the fields that can be expected from your work? Why does the United States need it? So those kinds of arguments can really be developed in detail by those letters. And if they're from government agencies, they have extra strength in, pushing the strength of your petition to the next level. Another type of NIW letters can be designed to support the second prompt, which is well positioned to, to advance your endeavors. So as I mentioned before, the second prong, the focus is on the individual, and they really look for an individual's record of success in similar endeavors that really positions them well to continue doing this impactful work in the United States. So you may get letters from your previous employers confirming your leading role in particular projects that resulted in a significant impact to the field, such as the development of new technologies, how this was commercialized, or research projects that received a lot of attention from other experts in your field. Those kinds of narratives can really elevate your profile and support the second prong. Now, it is important to really look into who is writing the letter. So you shouldn't really plan to get a letter from someone who is at your level in the industry, well, unless if you're someone who's already at the top. But it is good to get letters from those who are already known as leaders in the industry. So leading experts who have decades of experience are typical referees that we use for those types of petitions. We would typically add attach their full curriculum vitae, their full resume with the letter, so that the USCIS officer can see what kinds of relevant evidence the expert has that will, convince them to rely on their opinion a little more. And really, what we're looking for are people who occupy senior positions in leading institutions for O-1A and EB-1A, peer leaders in your industry for the NIW. If you can get an expert letter from a government agency, that can be a very favorable addition to your file. Now, another thing to ask is, how does the individual know you? Now, it is important to have a mix of what we call independent letters and inner circle letters, right? So independent experts are people who haven't directly worked with you, but they're nevertheless familiar with your work through your reputation in the industry, right? And they can confirm, they can provide a little bit more objective assessment that your abilities are outstanding in your field, or that your work stands to impact the field in the context of an NIW. By contrast, inner circle experts are experts who have directly worked with you in the past, and they play a different role, and they are also important to have because those types of letters can speak in detail regarding your past achievements, and they can provide more, context and narrative, so as to why they were important, what kind of limitation in the industry did it solve, and what positive impact resulted from this work. They can really provide the granular details, the concrete details that other experts may not be able to provide because they have actually been involved in your previous projects. So those types of letters also play an important role in contextualizing your achievements in both types, both extraordinary ability and NIW petitions. So then the last thing to think about is what is the content of those letters? What do the letters need to discuss? What kinds of content does the USCIS expect to see in those letters? And what we would like to say here is specificity is very important. So really, they're looking for specific examples and letters that are tending to be formulaic. And if they simply repeat the regulatory requirements, they're not going to be as effective as letters that really delve into the concrete details of, the case studies of your previous projects, in the case of extraordinary ability petitions, or in the case of an NIW letter that is confirming the national importance of your work, really delving into the detail of your proposed endeavor and explaining why this is needed and why your work can change the field for the better. So really try to develop these specific examples that contextualize your achievements for the USCIS officer. All right, so then let's shift gears a little bit and talk about some strategic considerations that can impact your decision on choosing which category to apply for. So the first question to discuss is, do you want to stay in the United States temporarily or permanently, right? And that is really a question that depends on the person and the person's, personal plans for the future, right? So as Kelly mentioned before, both the O-1A and O-1B visas are temporary non-immigrant visas. They're well suited for people who have work in the United States. They want to engage in this work, not necessarily, looking for a permanent home in the United States. And really, there is no minimum period of time you need to stay in the United States for those O-1 visas. So that can give you some flexibility if you still have strong ties with your home country and need to travel back and forth often, or need to spend long stretches of time in your home country. The O-1 visas can give you that flexibility. And it is worth noting that the O-1 visa, there is no lifetime limit to how many times you can extend the O-1 visa, right? So if you continue to have extraordinary ability work lined up for you in the United States, you can renew the visa, you can, get extensions. So there is really no hard and fast limit to how long you can stay even. So this can be a very flexible and good option for that kind of circumstances. Now, by contrast, the EB-1A and NIW EB-2 green cards, both categories are, really intended for people who want to live in the United States permanently. And once you get the green card, it gives you a lot of rights, but it also gives you some responsibilities. So you need to make sure that you're aware of what you're signing up for. For example, you do need to stay a minimum period in the United States and cannot stay too long of a period abroad. Otherwise, you're at risk of abandoning your permanent resident status. So those kinds of life choices, you may want to research in advance before making the decision. Now, another thing is once you get the green card through EB-1A or NIW, it also opens up the pathway to US citizenship. So if that's something that you're interested in the future, the green card will put you on the path to going towards that. The other question is, do you have a US-based employer or agent who is a US citizen, or do you want to self-petition, right? And this is what I alluded to in the past, in the previous slides when I was discussing the NIW. The EB-1A and NIW are both green card options that allow for self-petitioning, which means you do not need a US job offer. You do not need a US entity or a US agent to drive forward the petition. You yourself as a foreign national can be the petitioner of your case. So that is one advantage that could work for you if you do not have those ties, or if you're driving the petition entirely from abroad. By contrast, the O1A and O1B, they do require a US employer or a US agent to be the petitioner for the case. Now, one thing to note though is for entrepreneurs, for the O1A, right? So if you have your own company, a US entity that you set up in the United States, for example, if you're, starting up a startup, and if you can prove that there is, US-based extraordinary ability work lined up for you in different ways, for example, through letters of intent or a contract with clients, that is certainly one option you can use. So even though you yourself cannot be the petitioner as a foreign national, your US company could potentially act as, the US-based petitioners because your US company is nevertheless a technically different legal entity than you yourself, a foreign national. So this part, if you, definitely speak to an attorney if that's a fact pattern that you're working with, we would be happy to help you strategize on how to position that for success. Finally, the question that we should think about is family considerations, right? So for the O1A and O1B category, as Kelly mentioned in the previous slide, your spouse and children, minor children under 21 and unmarried, can join you on the O3 dependent visa and come to the US with you, and they can study. However, no work authorization is available for the spouse. By contrast, for the EB-1A and NIW, they are green card applications, and once you are eligible for the green card, your spouse and minor children under 21 and unmarried can also apply for green cards as dependent green card holders. And if you're applying through the I-485 adjustment of status option, if you already are in the United States on a different non-immigrant status, you're eligible to, apply for EAD, an employment authorization card. You're also authorized to, you're also allowed to apply for a travel authorization. And those kinds of benefits are also available to those dependent applicants who apply for the I-485 alongside you. So this can be a significant advantage depending on, what your family is interested in. All right, so then let's talk a little bit about moving from a non-immigrant visa to a green card, right? So you may already be in a different non-immigrant visa category, such as an O1, or you may be on an E2, or you may be on an H1B. What are the considerations when you try to move to a green card, right? So the first thing to note is qualifications. The green card categories have a different standard with which the petitions are judged. Compared to the non-immigrant visas. And Kelly mentioned this earlier on the O1A slides, but although the regulatory language is very similar, the EB-1A standards are scrutinized much more strictly than are, when you're applying basically with the same regulatory language, but, in the context of an O1A or O1B visa. And jumping from an O1B particularly to an EB-1A could be, even more difficult because the actual standard for extraordinary ability is different. For example, if you to qualify for an O1B, you may only need distinction in the arts, but you do need to, show sustained national or international acclaim, the very small percentage whoever is in the very top of their field if you want to qualify for an EB-1A green card. So that can be a particularly big jump, which is why it could be in some cases a good strategy for someone who is already on an O1A or O1B to really spend some time strengthening their profile and collecting stronger evidence among each of those prongs before you, try your luck at applying for the EB-1A. So some strengthening of your profile could really be beneficial for you if you're gearing up for an EB-1A in the future. Another issue to go over is timing, right? So it is important to note that some visas are harder to extend or subject to more scrutiny once an immigrant petition is filed. And it is important to note that both, the NIW, EB2, category and the EB-1A petitions are immigrant petitions. And once you file those immigrant petitions, it is in the record that you have filed such a case. So for example, let's say you're on a TN visa. And a TN visa is a category that is very strictly scrutinized for non-immigrant intent. So in order to continue to qualify for the TN visa, you need to show that your intent to work in the United States is temporary. But let's say you already have filed an I-140 under, NIW, EB-2 NIW category, for example. The next time you go to the border, they may see this on your record, and they may ask you questions about what your intents are. Do you really intend to come here to the United States to just work, or do you intend to immigrate in the future? And you could get a little bit more scrutiny and have a tougher conversation in those kind of circumstances. So if those kinds of issues are what you're working with, definitely speak to your lawyer. It may be strategically a good idea to arrange the timing of those petitions in such a way that minimizes those risks. So the final issue to go over here is family and timing issues regarding family, right? So it is important to note that the right for your minor children to benefit from a derivative green card, it ends at their age 21. So if you have younger children who may be reaching the threshold age soon, it may be a good idea to go ahead and apply for the green card in order to give sufficient time for a green card process to take place to avoid them aging out if that is a priority for your children. So the last question to answer here in this presentation is, are extraordinary ability categories available for entrepreneurs? And the answer to this question is yes. And there are a few reasons why. So the first reason is that the EB-1A and NIW both allow for self-petitions. They do not require a US-based sponsor. They do not require a US job offer, meaning that both are possible options for entrepreneurs who may not have, a different company that is willing to sponsor them as a worker. The second reason is that there has been changes in the EB-2 NIW adjudication standard under the case matter of Denisar, which made the EB-2 NIW a much more approachable category for entrepreneurs. And in early 2022, we also saw some announcements regarding the USCIS policy that they use when they adjudicate entrepreneur petitions. And they really expanded the category of evidences, that entrepreneurs could submit to support that either their work has national importance and substantial merit, or that they're well positioned to advance their endeavor, or that on balance it is beneficial to exempt them from the labor certification requirements. So entrepreneurs now have a wider universe of evidences to work with when they're applying for the EB-2 NIW. Finally, one thing that I want to reiterate here is that if you're an entrepreneur, it is possible to apply for an O-1A visa if you have extraordinary ability as an entrepreneur. You just need to have a separate corporate entity in the United States, a US legal corporation, or LLC, that can act as the petitioner driving forward your case. So you yourself as an individual cannot be the petitioner. However, your entity, the US entity that you set up in a US state, that entity can serve as the petitioner. So it can be one viable way for entrepreneur to move forward with an O-1A. All right, so we'll go over some questions and answers that have come in. So someone who has a master's degree, STEM, trying for the NIW EB-2 green card, definitely schedule a consultation with us because in the consultation, we'll be able to look at your resume and really look at the specific facts of your case and, give you informed assessment on if this can be an option for you. Next question here, I have heard USCIS officers only spend about 30 minutes reviewing each case. I've heard of people submitting no letters and others submitting 7 letters and each getting accepted. Interesting question. Definitely depends on the strength of each case and how are you supporting that your work has national importance. So let's say, you have a Google Scholar and you have, like 1,000 citations, and let's say you have a letter of support from a government agency saying how your research is super important for that particular government agency. Maybe those kinds of situations you can go away with 1 letter. However, in other types of cases, you may want to significantly bolster the materials because some of the arguments may have weaknesses. So definitely is a fact-specific inquiry. There is no real cookie-cutter way or a real minimum or maximum number of letters that we could provide. Really, the strategy is tailored to the strength and weaknesses of each case. When you say a letter of government agency would be useful, what do you mean by that? What sort of agencies? Also, for example, if you are a researcher in astrophysics and if you get a letter of support from NASA, that is a clearly relevant government agency that is active in the field. Or if you are a environmental scientist and you get a letter of support from, the Department of Energy, for example, regarding some clean energy initiatives that you're helping out. So those kinds of relevant agencies that are tasked with advancing, knowledge in the field that can really help your case. Kelly, do you want to take the next few?
Sure. Yep, absolutely. So someone's saying, will both count as original contributions of major significance, working on an app benefiting millions of patients, working on a second app that is increasing Medicare coverage, both happened 8 to 10 years ago. So, I mean, yes, like ultimately, as much kind of evidence that is strong that meets the criteria, you want to include, but you can't, you still need to meet 3 independently. So I'm not sure if the question is getting at that. Because if it is, then you would still, you can't say, well, I had 2 contributions of major significance, therefore, that's 2 of the criteria that I need to meet. You still have to meet independently 3 of the criteria, but certainly it would strengthen your case if within each of those, let's say if you're a member of, 7, outstanding, associations as opposed to 2, that's obviously better, but you still need to meet at least 3 of the criteria separately. Someone's asking about sharing the link to book an appointment. We can put it in the chat, but also if you just look here on the questions and answers form of the PowerPoint, that's also going to be shared. The link is right there. Additionally, if you Google Scott Legal and you go to our website, there's a button that says schedule a consultation, and you can schedule it that way as well. Someone's asking about whether we work on RFE responses, even if we didn't do the initial petition. We do. In terms of costs, just contact us separately, and we can always discuss how we handle those engagements. Someone's asking about whether they have 3 patents but no usage. Will that help in fulfilling any criteria? I would suggest scheduling a consultation. All of that is going to be really kind of specific to what else you have and your background and your profile. So happy to discuss that in more detail on a consult.
All right, so it looks like we have answered all questions that came in. Thank you, everybody, for your participation. Hope this information was helpful. Thank you, Kelly, for sharing your expertise, and I hope we see everyone in the future. Bye.
Thank you.